Nearly 2 decades ago, when President George Herbert Walker Bush, working with a Democratic majority in the Senate and a Democratic majority in the House, ably managed and led by the gentleman who is now our majority leader, who was then Congressman Hoyer, enacted a landmark piece of civil rights legislation called the Americans with Disabilities Act. The act has always had great promise. It came from a great consensus to do the right thing by Americans to help them achieve their highest potential, irrespective of their abilities or disabilities. It was a law that has enjoyed broad support and done much good. But I would scarcely say that nearly 2 decades ago, when President Bush signed that bill and leaders like Mr. Hoyer made it possible, that they certainly would not have thought that we'd be sitting here in a situation where muscular dystrophy is not a disability, at least according to some of the federal courts of the land. Not be sitting in a situation where carpal tunnel syndrome is not a disability, according to the United States Supreme Court. Where we'd be in a situation where a severe vision impairment is not a disability, according to the United States Supreme Court. Suffice it to say that what I believe are tortured judicial interpretations of the definition of a disability have put us in a position where the Americans whom we sought to protect under that law are not enjoying the full and robust protections of the law. The Americans with Disabilities Act essentially has 3 concepts. The first is that no American should be deprived of the right to pursue his or her best objectives and best aspirations because of any disability. And it defines disability. Second, it says that there cannot be discrimination or mistreatment based upon disability. And third, it sets up a process where, in the case of our jurisdiction, employers and employees can determine what reasonable accommodations can and should be made so that a person with a disability can reach his or her highest potential. It is my judgment, based upon the history of the last nearly 20 years, that the judicial interpretations of the meaning of disability have severely undercut the effectiveness of this Act and severely excluded a lot of worthy Americans from the Act's protection. As he did nearly 2 decades ago, Mr. Hoyer has responded to this concern. He has introduced legislation which would correct these judicial misinterpretations, and we are privileged that he is with us this morning to discuss his legislation, to discuss the underlying problem, and for this committee to begin the process of debating on a bipartisan basis what the best solution to the problem is.